Hello, and a very warm welcome to everyone attending today. My name is Philip Hoddell, and I'm the chairman here at Burkitt Long. I'm delighted to be able to introduce this Wednesday webinar. As you may know, Burkitt Long are offering regular webinars on a wide range of legal topics. Future subjects will include the creation of value through trademarking, an update on employment law, and a session on statutory wills. If you're interested in any of our webinars, please sign up at www.burkittlong.co.uk/events. Today's topic is entitled Myths on Divorce. It will be presented by Mel Loxley and Lisa Collins, two partners in the divorce team. Lisa and Mel will dispel some of the more common misconceptions about divorce law, offer some useful tips, and of course, take questions at the end. So without further ado, I will hand over to them for what promises to be a fascinating talk.
Thank you very much, Philip. My name is Mel Loxley, and I'm a partner and solicitor in the divorce and family team at Burkitt Long. I'll be joined by my colleague, Lisa Collins, a little later on. We will take questions at the end, as Philip said, so please do make use of the Q&A facility, and we will go through those when we get to them. So today we're going through the myths on divorce, and we've come up with a number of common myths that I'd like to take you through. So the first myth that we're going to deal with is it possible to obtain a quickie divorce? Sadly, that's not actually the case. As some of you may well be aware, no-fault divorce came in April 2022. No one actually knows how long the new no-fault divorce will take, because we only recently reached a stage where we can apply for a conditional order, which used to be called a decree nisi. A recent application that the firm has made for a conditional order has resulted in that date for it being fixed in early October, so we are anticipating probably a 4-week turnaround at that end of things. So because we haven't yet reached the date where we can apply for a final order, it's difficult for us to judge exactly how long it's going to take. We do know that there are inbuilt periods for reflection in the new process, which mean that even if the court processes each stage as quickly as it can, it's probably going to take at least 7 months from start to finish. Unfortunately, the court has struggled with quite significant delays in recent years and continues to do so. As such, I anticipate that divorces are probably going to take a bit longer than 7 months, and I imagine most will take between 8 and 12 to get from start to finish. Should you finalise your divorce as quickly as you can? Well, actually, that very much depends on your circumstances. Finalising your divorce not only ends the marriage, but it also impacts on pension rights, inheritance, and also death in service benefits. So for that reason, I'd strongly recommend that you take specialist legal advice before you apply for the final divorce order, previously known as the decree absolute. Myth 2. It is impossible to bring a financial claim after divorce. It is untrue. Please don't make the mistake of assuming that because you're divorced, that concludes the financial claims that you can bring against one another, as it doesn't. On divorce, you have financial claims against one another for property, lump sums, maintenance, and also pensions. And there are only 2 ways to bring an end to those claims. The first is where you secure a final clean break order from the court. And the second is where you have remarried without preserving those claims, either within your within your divorce application, or by making a separate financial application to the court before the remarriage. In that second situation, it's important also to appreciate that whilst you won't be able to bring those claims against your spouse can still very much bring those claims against you unless they have also remarried. So as such, please don't remarry until you've taken legal advice and resolved those financial. As we've put on the slide, the best time to agree the finances is actually when you separate. Whilst everybody appreciates it's an incredibly difficult time for the couple, life is very busy, life is very complicated, and resolving the finances months or even years after the separation makes doing so far more difficult. Any agreement that you reach must be converted into a court order or it won't be legally binding. And that's a thread that I'm going to pick up on a number of times through this webinar. So when can you apply to get the court order legally binding? Well, the answer is at any time after the conditional order has been granted, which was previously known as decree nisi. Myth number 3, in the divorce courts, wives always get 60% of the assets. They do not. In fact, the starting point on divorce is actually a 50-50 division. But the court has a very wide discretion and will take into account all of the circumstances of the case and also a list of statutory factors that it's required to. The court may well depart from equality in a number of different circumstances, including where an equal division doesn't meet needs, and particularly where those needs of the children of the marriage require more than 50%, as needs of the children are actually paramount. Other reasons for departure from equality include contributions such as premarital wealth or inheritance, and I'm going to turn to those topics a little bit later. Does the court have to be involved? No, thankfully it doesn't, at least not at the outset. It's far better for couples to explore whether they can reach an agreement without court involvement. And there are a number of different options to choose from. So some couples have direct discussions, others choose solicitor negotiation, mediation, and also collaborative law, which is where the couple have 4-way meetings with their 2 collaborative lawyers all around a table. And the lawyers help to facilitate discussions between them and reach an agreement. Once that agreement is reached, as I've touched on before, it's crucial to convert that into a court order so it's then legally binding. Even at that point, it doesn't mean you have to attend court. What we can do is simply submit a document which we call a consent order online through the court portal. We support that with a summary of the finances of yourself and your spouse. And a judge will then sit in their chambers and consider the agreement reached. And if that appears to be fair and in order, then the order is actually granted and then disseminated through solicitors or the parties directly if they're dealing with it in person. Moving now on to myth 4. The highest earner keeps most of the money on divorce. Again, it is a myth. They do not. In fact, the opposite may well be true due to the fact that the high earner will often have a much greater mortgage capacity than the financially weaker party. Contributions of breadwinner and caregiver are very much viewed by the court now as equal. That hasn't always been the case, but it is nowadays, thankfully. Determining the finances on divorce is often the hardest and probably most emotive issue on divorce, aside from the children issues, which Lisa's going to pick up with you in a little while. As confirmed before, the court has that really wide discretion and the checklist of statutory factors that it takes into account when determining the claims. The court will treat the children's needs as paramount, and if the financially weaker party is the caregiver, they may well receive more than 50% to ensure that they can meet the housing needs of themselves and also the children, at least during the children's minority. The court will take into account all assets, including pensions. In the past, I think pensions were perhaps glossed over by the family courts, but it's definitely not the case anymore. Pensions obviously provide an income stream. in the future. And if they're not shared fairly at the time of the divorce, then that will actually result in one person having a much better standard of living potentially than the other in retirement. So it's crucial that they're considered at the time of the separation. It's also crucial that when you separate and divorce, there is full and frank disclosure exchange between the parties, so that both parties know exactly what assets there are to be divided and can make an informed decision. Ultimately, the court will divide the assets in a manner that is fair and reasonable in all of the circumstances of the marriage. Myth number 5. If you have not worked for a long time, your spouse will have to pay you maintenance for the rest of your life. That is certainly not the case anymore. Maintenance is effectively a claim that one spouse can bring against the other for income. And historically, we used to see quite a lot of joint lives maintenance orders, which basically means that maintenance is paid until the death of the first party or the marriage of the recipient. Joint lives maintenance orders are now very, very rare. There's actually no set formula that the court applies when calculating spousal maintenance. It's a case of assessing the overall income and earning capacity of each party against their reasonable needs. And if one party has a surplus and the other has a shortfall, then that may well be a situation where spousal maintenance is appropriate. Both parties are under a duty to maximise their own income. So even if they haven't worked for a while, they then have to explore what work they can secure, what benefits they are entitled to. And obviously benefits will need to be taken into account when assessing whether they can meet their own needs. It's important, however, to be aware of the impact of spousal maintenance on certain benefits. So, for example, with universal credit, that's actually reduced pound for pound by spousal maintenance. The court will strive to achieve a clean break wherever possible and as quickly as possible. And by a clean break, what I mean is the end of maintenance and the end of all financial ties between the parties. So nowadays, where spousal maintenance is ordered, and as I said, that is really in the minority of cases now, it's only generally for a few years at most, and in that time the court will expect the dependent party to gain independence, so that by the end of the maintenance order they are living completely independently of the payer. We're now moving on to myth number 6. When I divorce, I'll keep my assets from before the marriage and any inheritance I have received. Unfortunately, the answer to that is not necessarily. There is a legal distinction between matrimonial assets and non-matrimonial assets. So matrimonial assets are assets that are derived from the efforts of the parties to the marriage during the course of the marriage itself. Non-matrimonial assets are assets from a source outside of the marriage, so for instance, premarital wealth or inheritances. The court's starting point with matrimonial assets is equal sharing, as I mentioned previously, but that's not the case with non-matrimonial wealth. The court won't generally share non-matrimonial wealth unless needs cannot be met without doing so. So as for the question, can your spouse claim against your inheritance? The answer is yes, if their needs can't be met without sharing it. And again, the needs of dependent children are paramount, so that is a really important factor to bear in mind. If it is necessary to share an inheritance, however, the court won't approach the inheritance in the same way as it would matrimonial wealth. It will be viewed by the court as an unmatched contribution by one party. So the court won't approach it with a view to sharing it 50-50, but only really sharing it insofar as needs dictate it must. Obviously, there can be quite a big question mark about what reasonable needs are. Can an ex-spouse claim against a future inheritance? Courts don't ordinarily take into account an inheritance that's likely to be received in the future because there isn't any certainty when or if it will be. Bear in mind, however, that as I touched on previously, if you don't resolve the financial claims between you in a court order, and you then come into an inheritance, that inheritance may potentially be shared with your ex-spouse if they cannot meet their needs without it. So can a spouse claim against assets you had before the marriage? Just as with an inheritance, the court can share premarital wealth if needs require it. Generally speaking, the longer the marriage, the stronger the financial claims become. But bear in mind that when considering the length of marriage, the court will take into account seamless cohabitation. So, for example, if a couple who live together for many years, they marry for a couple of years and then separate, on divorce, the court will probably view that as a long marriage, even though the marriage itself has been fairly short. Thankfully, more and more couples are realising the importance of protecting the wealth that they bring into a relationship. Prenuptial agreements are really effective at doing that, and our team prepare many of these, and more so in recent times. If it's the case that you have married already without a prenuptial agreement, or if you've got insufficient time before your planned wedding to safely put in place a prenuptial agreement, then a postnuptial agreement is equally as effective. And again, we have lots of experience in drafting those also. We now move on to myth 7. A separation agreement is legally binding. Sadly, that's not strictly true. So separation agreements are very good evidence of any agreement that has been reached, but they don't prevent an application being made to the court by either party at the time of the divorce. As such, if one person is unhappy with the terms of the separation agreement, then at the time of the divorce they can seek to renegotiate it, or if that's unsuccessful, they can ultimately invite the court to exercise its powers afresh. So the only way to secure an agreement that's legally binding is by securing a court order. Unfortunately, you can't secure a court order without starting the divorce proceedings, as I mentioned earlier, because you must have reached the conditional order stage, previously known as decree nisi, for the court to be able to approve that order. If you're in a relationship and you just don't want to start the divorce proceedings straight away, then of course you can enter into a separation agreement, but you just have to be mindful that it's not a cast iron guarantee. That being said, it's absolutely better to have something in writing than nothing at all. What I would say is that if you are going down the separation agreement route, please don't draft it yourself. They are complex documents. They must be prepared by a specialist family lawyer, such as Lisa or myself, to make sure that they cover all relevant issues and leave no room for uncertainty. Your solicitor can draft this in a way that makes it as strong as possible by ensuring that both parties have secured independent legal advice, that it meets needs, that there's been full and frank financial disclosure, and that neither party is being placed under any pressure to sign it. In those circumstances, assuming both parties remain happy with the separation agreement at the time of the divorce, then it can simply be converted into a court order at the conditional order stage. I'm now going to hand over to my colleague Lisa Collins, who's going to run through the remainder of the myths on divorce topics that we're covering in today's webinar. Thank you.
Thanks, Mel. Good afternoon, everyone. So if we could move on to the next myth, number 8, which is once you are separated, your spouse ceases to be your legal next of kin. This is not true. Your spouse does not cease to be your legal next of kin when you separate. And in fact, whilst you remain married, your husband or your wife is still regarded as your legal next of kin. What this means, sorry, could we have the next slide? Thank you. What this means is after you die, or sorry, if you die after you separate and have not divorced, there is a financial risk. If you have not updated your will, your husband or your wife may still inherit, or if you die without a will, your husband or wife can make a claim against your estate. This then leads us on nicely to the issue of jointly held property. Not many people know this, but there are 2 ways that you can hold a property jointly. First is as joint tenants, and what that means is that you each own the whole of the property. In the event of one of your deaths, the survivor then automatically inherits the property, irrespective of what is in any will. The second way you can hold property jointly is as tenants in common. This allows you to specify how the property is held, for example, half each, and you can then leave your share to another third party by way of a will. So if you are separated and you own a property jointly with your spouse, it is worth checking whether you are joint tenants or tenants in common. If you hold the property as joint tenants, you should consider severing the tenancy so as to become tenants in common. This will give you greater control over what happens to your share of the property in the event of your death. The process itself to sever the tenancy is very quick, it's very easy. Usually takes no more than about 2 weeks to complete and register any change with the land registry. It is extremely important that if you are separating from your husband or wife, that you take legal advice about the implications. It's not always the most glamorous of subjects, death, but it can help ensure your estate is left in accordance with your wishes. So moving away from death, our next myth, number 9, after a divorce, children This is more right and right to the child or the children, both of their parents. When parents separate, it's possible to reach agreement about the arrangements for the children or the child. One parent, and they can live with both on a more equal basis. Just bear with me, my computer's decided to freeze. There we go, that's better. If no agreement can be reached, then parents have a few options. One is that they can engage in mediation. Another is that they seek advice from a solicitor, or as a last resort, both parents can make an application to the court. The court will then determine the long-term arrangements for the child or the children. Now, as Mel alluded to earlier, in the event court proceedings prove necessary, the paramount consideration of the court will be the welfare of the children. The court will also have a checklist of factors that it applies before making any final decision. These can include the ascertainable wishes and feelings of the child or children concerned. I should add that the child or children's wishes will always be considered in light of their age and their understanding. It's not automatic that they're followed. What the needs of the children might be, so whether they're physical, emotional or educational. The impact on the children of any change to the current circumstances is also important, as is how capable each of the parents are, and indeed whether there is any risk of harm to the children. Now, it is important whenever parents separate that they consider what the arrangements for the children should be very carefully. It goes without saying that it's always better if agreement can be reached outside of court. Staying on the subject of children, our next myth is myth number 10. If you do not see the children, you do not have to pay child maintenance. Again, this is not true. Notwithstanding any difficulties that there may be in respect of the arrangements for the children, there is an obligation on the parent with whom the child or the children does not live to pay child maintenance. The issue of child maintenance is separate to that of the arrangements for the child or the children, and in other words, you will have to pay child maintenance whether or not you see the children. This brings us on to the question, how much should you be paying? Or put broadly, the amount payable is a percentage of your gross income less your pension contributions. The actual percentage applied is dependent on a number of different factors. This will include the level of your income, it will include the number of children that you're paying for, whether you have any dependent children living with you, and how many nights on average they spend with you. If you wish to find out how much you should be paying, I would advise looking online at the child maintenance calculator, as that can be much more specific than I can, And on the screen in front of you, there should be a link to the government calculator. Some other considerations when considering child maintenance are also on the slide. The first is dividends. When calculating child maintenance, dividends are not initially taken into consideration. But where the paying parent is in receipt of dividends, an application can be made for a variation if the total received is more than £2,500 each year. I should also add the same applies in respect of other non-earned income, for example, rental income. Another point to note is that the child maintenance calculator only takes into account a maximum of £3,000 per week. If your weekly income is more than this, again, an application can be made, this time to the court, and this time for something called top-up maintenance. In this instance, the court has discretion about what to order, so how much, but it will broadly be based on what the children or the child needs. The final point on our current slide is that some people often mistakenly believe that if they're paying child maintenance, that they are able to determine how the funds being paid are to be spent. That's not correct. The person receiving maintenance is able to spend it as they wish, and the paying parent is not entitled to ask how or what the money has been spent on. Now, still on the subject of child maintenance, we're often asked what happens if there is an agreement in place whereby the paying parent agrees to pay for things such as shoes or clothing, or continues to pay the mortgage payments or other debts in the receiving parent's name. In this instance, it can be possible to apply for something known as a special expenses variation. Now, debts and mortgage payments can be taken into consideration, but things such as buying clothes and shoes, they're very unlikely to be taken into account. Now, as with the arrangements for the children, it is possible for parents to agree the amount of child maintenance that should be paid. If they do, then my recommendation is that any agreement is recorded in writing. That's whether it's in conjunction with other financial issues or separate to them. If child maintenance is agreed as part of any overall financial settlement, so on divorce, then it can be recorded in a financial order. But it is important to note that after 1 year of that order being in place, either parent can then apply back to the child maintenance service to have the amount reviewed. If no agreement can be reached, parents can try mediation. They could seek advice from a solicitor, or alternatively, and in most cases, it's likely one parent will make an application to the child maintenance service for an assessment. In that instance, the calculator that I referred to on the previous slide will then be used. If we move on from children now, our next myth, number 11, couples who live together without marrying become common law spouses. Now, I'll start this one by saying there is no such thing as a common law spouse. It does not exist. Our law recognises married couples, and it recognises couples who have entered into a civil partnership. Any other couple is legally defined as an unmarried couple. Couples in unmarried relationships have no claims against each other for capital, income, or pensions. They could live together for 30 years or more and still have no claims. Unlike married couples, unmarried couples are under no duty whatsoever to support one another financially. There is, however, a difference for children. Unmarried couples, or unmarried parents, I should say, both need to contribute to a child's financial need. If one parent does not, the other can bring a claim against them to ensure that that child is adequately housed and has any other needs met. Now, if as an unmarried couple, you wish to regulate your financial responsibilities, but you do not wish to marry, then the best thing you can do is to seek legal advice, as there may still be steps that we can put in place to help protect you both. So our final myth for today, perhaps the most controversial maybe, number 12, everything is usually fine until you involve a lawyer. So as lawyers, we often get accused of complicating matters or making them worse. Having practiced as a lawyer myself for now over 12 years, I can honestly say that's not what we do. It is important that you receive the right information and advice to protect you and your family. And in all honesty, the only person qualified to advise you on all aspects of separation, so divorce, finances, and children, is a divorce and family lawyer. Support from friends and family during difficult times can be helpful and no doubt invaluable, but when it comes to legal advice, your family is unique, and so you need advice that's tailored to your circumstances. A relationship breakdown can be an emotionally difficult time, and the law around it can be very complex. Obtaining early advice from expert lawyers means you will know and understand exactly what your options are going forwards, and it can place you in the best position to avoid any potential pitfalls. If you're not sure who you should instruct, then I would suggest you start by looking for a lawyer who is a member of Resolution. Resolution is an organisation with over 6,500 divorce lawyers who have all adopted a code of practice. And that code of practice promotes a non-confrontational approach to family problems. Members all work in a way that is sensitive, it's constructive, it's cost effective, and perhaps most importantly, it's the most likely approach to result in an agreement. The website, Resolution's website, which you should see on the slide in front of you, has some really helpful resources. So feel free to have a look at those after this webinar. And just to add that at Burkitt Long, all our divorce and family lawyers are members. Another myth is that people often think involving lawyers automatically means you have to go to court. Again, that's not true. And when dealing with family disputes, there are many alternative options available, some of which we've touched on already today. Court is the option of last resort. Lawyers will always work with clients to choose the option that is best for them and their family. As lawyers, we will also ensure that our clients are advised in plain English, in a way that is easy to understand, and we will, wherever possible, try and avoid legal jargon. When assisting clients to resolve disputes, we also try hard to encourage constructive communication. As referred to earlier, we do not run straight to court. We look at alternatives such as mediation and negotiation, and these are always encouraged. We could have the next slide, please. Thank you. Now, the big concern of many clients is the cost of instructing a lawyer. If you take away anything from this webinar, let it be this. The actual cost of instructing a lawyer varies from case to case, and it also depends on the issues involved and the approach to the case, not just by us, but by the others involved. If you are able to obtain early advice in relation to your position, you are enabling constructive discussion to start straight away. This then presents you with the best opportunity to obtain an early resolution. It then means that you don't end up incurring significant legal costs. Early advice also means that you can avoid potential pitfalls, which often take time and money to resolve. At Burkitt Long, we believe in being clear and upfront regarding costs, and these are also kept under review as the case progresses. The costs involved are also compared to the benefits, so as to ensure that they do not become disproportionate. As lawyers, we are under a duty to act in your best interests. So the next point on the slide is that both do not have to instruct a lawyer. That's true. It isn't necessary for both parties to instruct a lawyer, but it can be helpful to keep discussions constructive and allow for an early resolution. But as I say, it is not necessary. Finally, what should you do if you're not sure what to do? Well, firstly, do not worry. It's absolutely fine. Lawyers can help take you through your options, and we will never take any steps to contact your partner or any other third party without first telling you or obtaining your agreement. We can also help you explore and encourage reconciliation if you feel that there is a chance that your relationship can be saved. That brings us to an end of the main part of our webinar. And just before we take questions, just to let everyone know, we will be sending a recording of this webinar around to everybody that's signed up today. That will be sent tomorrow morning. We'll also include a link to a very short feedback survey, which I believe should be on your screen in front of you now. And we would really appreciate it if you could complete it so that we can start to make sure our future webinars are helpful to you. As I think Philip said at the start, this is one in a series. Our next webinar are marks value creation. That's on 5th of. If you're interested in this or any or others, visit our website page. Let's move on to some questions.
Great, thank you, Lisa. We have had some questions come in. With the first one, which I think Mel is going to answer, is to give you a little break, Lisa, is from somebody anonymous. My husband had a house when we married and I didn't, so technically he put more in at the start, but I have contributed and always work. When settling finances, will the court look at this? I think it would be hard to evidence given the amount of time that has passed. We married in 2002 and bought our first joint property in 2003.
Thank you very much for the question. Yeah, it's an interesting one, and I'm glad that you've raised it actually, so thank you. It sounds in this case as though your husband may well be able to assert that he made an unmatched contribution at the beginning of the marriage, but what I would say is that you've obviously been married for 20 years, and it sounds as though that money has then been ploughed into the family home. In those circumstances, the court is most unlikely to view that as non-matrimonial property because it's been very much intermingled with the assets of the marriage. I'd be very happy to have a free 15-minute consultation with you if you wanted to get in touch and discuss it further. Thank you.
Thank you, Mel. We've had another 2 anonymous questions come in. The first one is, I have been advised by a solicitor to try mediation, but the mediator suggests we each seek legal advice. Therefore, is it not cheaper to go straight to the solicitor?
I'm happy to fill this one too. So mediators perform a really valuable role where parties are able to talk with one another, but they need some assistance in perhaps resolving some issues that remain between them that they just can't get past between the two of them. The mediator is a facilitator of discussions, and they effectively help to navigate the issues that remain and see whether compromise might be possible. The mediator cannot advise either party, however, so it's really important that if you are going through mediation, beside the mediation process, you take legal advice on the discussions and the settlement proposals that are being made, so that you can make an informed decision about whether that is a fair agreement for you to make, and whether it's in your best interest to settle on that basis.
Thank you, Mel. We have another question. Let me know if you want Lisa to take this one, but it is, how does child custody work if one is unemployed and the other unemployed? Is the employed parent favoured?
Sorry, Katie, could you repeat that question?
Sure. It's, how does child custody work if one is employed and the other unemployed? Is the employed parent favoured?
No, not necessarily. As Lisa said, obviously all of the circumstances of the situation would be taken into account, and it's very much guided by what is in the best interests of the child. What you tend to find is that if one person has taken the primary caregiving role throughout the relationship, there's something of a status quo where it's anticipated that will continue to be the case. What I would say though is that if one person is available to meet the children's needs and the other person is working, then the court would probably prefer the child to be cared for by the parent who isn't working than be placed with a third party such as a nursery or childminder kind of setting. But again, it's a really interesting question, and we'll be happy to delve into a little bit more detail with it in a free 15-minute consultation if you'd care to contact us.
Thank you, Mel. The next one is for Lisa. Is my current partner has been separated from an emotionally abusive short marriage. He put all his inheritance, a substantial amount, into the family home, and it appears signed property over on separation. Is there any way he can get any of this back on divorce? He was emotionally weak when he signed the house over due to the abuse, under medical advice.
Sorry, Katie, could you, I missed the first part of that question. Would you mind repeating it?
Yes, of course. The question is, my current partner has been separated from an emotionally abusive short marriage. He put all of his inheritance, a substantial amount, into the family home, and it appears signed property over on separation. Is there any way he can get any of this back on divorce? He was emotionally weak when he signed the house over due to the abuse, and he's under medical advice.
Okay, thank you. I'm unclear as to whether or not your partner is divorced or simply separated from their ex-spouse. If they're divorced and the property was signed over as part of any financial settlement, then it may be difficult to go back and undo that. If they're separated but not yet divorced, then the financial claims that your partner has against his ex-spouse or current spouse remains open. So irrespective of the fact that the property has been transferred, the financial claims remain open and are capable of being looked at by a court or outside of court if agreement is possible. So I think it sounds like it might be a little complicated. So what I would suggest is, if you're able to, I'm not sure if you're able to within this format, but leave your number, then perhaps we can give you a call and have a free 15-minute chat. But certainly if they're not yet divorced, the financial claims are still open. So what I would say is that all is not lost.
Thank you, Lisa. We will have contact details at the end, so if that person would like to send Lisa an email, we'll have the email address up on screen at the end. We have two questions that were submitted in advance. The first one is no-fault divorce quicker than the old divorce process?
I'm happy to field that one, Katie and Lisa. Unfortunately, it's unlikely. Before the significant court delays that we've experienced over a number of years, we used to be able to get divorces through within 4 to 6 months. By the time that no-fault divorce was coming in, the old procedure was taking around 12 months to go through from start to finish. And I imagine that the no-fault procedure will take around that same kind of time scale, because the court is still experiencing the same delays. Whilst an effort has been made to very much streamline the process and to put it all online, which is great, there's still only the same number of court staff that are processing the applications. So I would imagine you're probably still looking at about 12 months, unfortunately. We also have to bear in mind that, as I covered previously, there might be good reasons not to finalise the divorce straight away. So if the financial issues still haven't been sorted out, then it may well be in a person's best interest not to finalise the divorce just yet. So again, if in any uncertainty, please come and have a chat with us and we can guide you through that.
Thank you, Mel. One more question submitted in advance is, do you have any top tips for divorcing couples?
Good question. Yeah, we have lots of top tips. I'm sure Lisa's probably got some of her own. I'm happy to share some of mine. Firstly, obviously take advice from a specialist family lawyer so you can make an informed decision. Secondly, keep open the lines of communication with your partner if at all possible. Try and communicate constructively, because the more that you can communicate well between yourselves, the less stressful and less costly the process is going to be. The third and final tip that I would give is really any agreement that you reach, make sure that you get it formally recorded after you've taken advice on it by a qualified solicitor who specialises in family law, so that we can make sure it's legally binding for you.
Great, thank you, Mel. That was all the questions for today. I'll just hand back over to Lisa to close the webinar.
Thank you.
Thanks, Katie. Well, thank you everyone for joining us today or this evening. We will review the questions that have been asked, or if we haven't managed to get through all of them, we will review those that we haven't answered and contact anyone we haven't had time to respond to. But as we've said, if anybody needs any further information or wants some further advice, we do offer a free 15 minutes, so do get in touch. Otherwise, I will leave you all to enjoy the rest of your evening. Thank you and good evening.
Thank you. Good night.